Good morning, folks. We are still on verdict watch in the Karen Reed trial. There's a lot to talk about, including, I think that there is this YouTuber that I became familiar with during the Murdaugh trial. She has created a 3D reconstruction of the prosecution's case and the defense's case. And we're going to take a look at some of that. We're going to go over some of the highlights of the evidence. There's a lot of questions that I think we all have, but I don't know. In a case where you have 30 days worth of testimony, um, what I've always found, no matter how complex the trial, is you always find one or two or three issues to break the whole thing down and dumb it down for yourself and just say that, look, if this is true, then guilty. If this is not true, then I cannot find guilty. For me, where I have planted my flag in the sand with respect to all of this, is what were the medical injuries? Was there evidence that the brake lights were manipulated? Is there evidence of a before and after, before the incident occurred and after the incident occurred, so I could determine whether or not the brake light was responsible for O'Keefe's death? And those were answered. There's some questions that haven't been answered. There's a lot of questions that don't make sense. A lot of the testimony from the officers has been oddly vexing, including statements that were identified in testimony where the officers were like, I guess the homeowner's going to take a lot of shit for this one, huh? And the reply was, no, he'll be fine. He's a Boston cop or something to that effect. Of course, I'm paraphrasing. So, we're in a day 4. Is it day 4 now of deliberation? Day 5 of deliberation? I would not be all that concerned about a hung jury just yet, just because there's been 31 days of testimony. Here's what I know about juries. They are either extremely efficient and have made their minds up very quickly, or you get some people in the jury that when they're deliberating, they literally want to go through every single piece of evidence one more time. There's even some juries that they won't even take polls until after they've gone through all of the evidence one more time. And in a case where you've literally had, we've been in trial now for 2 months. There was, I think, over 80 witnesses or something like that. It's going to take them a little bit of time to get through it. I'm not so sure in a trial of this length that you can read too much into the fact that they're still deliberating. They have that right. I had speculated the other day that I thought that first degree was off the table. They just did not prove that with any measure of certainty. There's certain things. Here's what I look at the most. Here's what impressed me the most in this case. Oftentimes, we are forced to litigate these cases without perfect facts. For example, when you have a breach of contract case, nobody wrote anything down, so it was literally a verbal contract. So how could you prove then that there was a contract? Well, you can prove that there was a contract by the actions of the parties involved. If you didn't have a contract, then why were you paying him on an installment basis for the last 18 months, a fixed amount of dollars, and receiving a certain amount of services? So you could fill in the gaps, even when things aren't written down. And if I'm filling in the gaps in this case, I got to say, I think back about what Lally's main theme in his meandering closing arguments were. And look, stylistically, he's not going to hold a candle to Alan Jackson. He's just not. Jackson is far more charismatic. He's far more fiery. This DA is not that way. And, for the most part, you don't really have to be as a DA. You don't. The styles is a study in contrast. I mean, you go back to the presidential debates from 1960, when you had JFK going up against Richard Nixon. And JFK was this young, vibrant guy in the sharp suit, good-looking guy, something that, and TV was relatively new. It was literally a new thing. I think it hadn't even really been widespread in existence for even, 12 to 15 years at that point. The first television broadcast, I think, being in 1939, imagine. Of course, movies were a thing, but as far as television sets being inside of your homes, that was not really a thing until the 50s. They had technology in the 40s, but it was expensive and clunky. And so in 1960, it's really the first time you had on display two presidential candidates where you're getting to see in real time, as if they were sitting in your living room, the difference between one candidate or the other and how they presented. You got to gauge a brand new variable, which was never the case before, unless you were sitting physically in front of the parties as they debated presidential issues. You got to see the very first time the differences in personality and temperament and speech patterns, and whether or not you had confidence in them as speakers or not. And JFK, like I said, vibrant, charismatic, good looking, killed it. And then Richard Nixon in this frumpy looking suit that he picked up at the Men's Warehouse. I don't know if they were in existence, but it was this frumpy looking, boxy looking suit. He looked like an old man, and he wasn't even that old. He wasn't even that much older than JFK, but his answers were less confident, even if he really believed in what he was saying. And after that debate was done, the general public shifted dramatically towards JFK. So if all you were doing was paying attention to the closing arguments in this case, it's really easy to get caught up in Alan Jackson's charisma and believe him when he tells you that this was an effing cover-up, because the Boston police officers acted so acrimoniously. They acted so their investigation techniques were so beyond or below par that this investigation cannot be treated. And he didn't really even have to stretch that far to say that. All you have to do is go to the statements when you're introducing in a trial statements such as, oh no, he's going to be fine because he's a Boston police officer. What is a jury supposed to make of that? And on evidence in direct exam, not even in redirect, did Lally really do much to combat those statements? All the best he really got out of it was, it was really unprofessional. I shouldn't have done it. You have officers going through her physical phone as opposed to a mirror of the phone, a download of the phone, a recreation of the phone data, because at that point, it's really important when you have electronic evidence like that, you're not supposed to, there's things on there that may be privileged. And so when you have a phone that's sitting there in evidence, it's supposed to be forensically copied and mirrored for everybody to go through, so that if there is redactable stuff in there that might be inadmissible, such as attorney-client privilege stuff or otherwise, it doesn't make it in to evidence. The other side, even if it's not admitted as evidence into the court, is not allowed to be privy to the conversations that you have with your attorney. And this effing guy is just going through her phone, no mirror, just her actual physical phone, looking for nudes of her, of which he didn't find any. He found a lot of other stuff, but he didn't find that. Give me a second. My co-host is calling me. Hello, Eliana, you're live on the air. How are you this morning?
I'm doing good. Sorry, I just had a consultation. But in the
You have a link. You have a link. Jump in. I'm already live. We're 13 minutes in.
Okay.
People are waiting on you.
Perfect.
Okay.
Okay.
Oh, amazing. She's not even here physically, and she's still late. It's I think it's the MO of the show. I can't really put too much blame on her. I got started late anyway. But yeah, you have you don't have to look very far to find malfeasance in the investigation in the case, to find things that are reprehensible, to find things that'll make you gag, or to make you say that this effing guy's a creep. I mean, you had a whole relationship between Reed and Higgins where she's trying to confide in this guy. Then, it's just not working out. This isn't what I expected. They shared a kiss on one night, and she's letting him know how attractive he is, and they share their mutual attractions for each other. And there's the aspect of a possible relationship. Why is that even important? Because it introduces, and interestingly, it was introduced on a cross exam. This was a prosecution witness, but we had to get here. A possible motive into a cover up. Was Higgins like so love struck with Reed that he concocted this whole plan, or had some shoving match with John inside the house, which the Apple data confirms that he was inside the house. And in the course of their shoving match, the dog gets involved and starts chomping on his arm. And then in his drunken state, he falls back and hits his head on the nightstand or something, some kind of a hard object, leading to his death, leading to an, oh shit, let's drag him outside. We can make this look like something. Interestingly, let's go back to what I was saying. You will know what happened from the actions of the people. Now, the prosecution has spent a lot of time trying to convince us that Karen Reed, the main highlight of their evidence is she confessed. She said, I did it. I did it. I did it. I did it over and over again. Jennifer McCabe comes in and says, I heard her say that. And then the question is like, well, then why didn't she tell the officers at the time when they were investigating that she did that so they could investigate a potential homicide? I think it's very telling that the law enforcement team involved in the case chose not to treat it as a homicide. They treated it as an accident. Why? You have somebody yelling, screaming at the top of their lungs that she ran him over with the car. That is an automatic homicide investigation. She's immediately detained. She's immediately placed under arrest. Maybe not under arrest, but taken back to the station. Hello, Ileana. You are now on stage. It's a pleasure to see you and your camera there. You have the benefit of Dominic's high-tech camera, so you have to look all foggy on your webcam.
Sorry.
Yeah, so we're discussing the Karen Reed, obviously, as you well know. We're in the day 4 of jury deliberations. I'm feeling kind of baby face. I just shaved. I don't like it. It's making me feel self-conscious.
You have your drink of choice already this morning?
Yeah. So one of the questions that I had, well, this is just water and honey. It's 9:49 a.m., miss. I could not in good conscience have whiskey right now. I have too much to get to. I'm a little bit over caffeinated. I got my yerba mate, which I just discovered, which is it tastes like shit, but it's it's good stuff. It's a caffeine delivery mechanism. Hey, so you remember when we had covered this case way back before we even started trial? I think going into the first week of testimony. What was some of the main what did you need to see to determine guilt or innocence of Karen Reed, whether or not she ran over John with her car?
I remember mentioning DNA, either DNA from the alleged dog bites or DNA on the car from I can't remember his name, from the guy that passed away. What else? I remember that we discussed also about the search of that other lady, how much it takes for a person to die from hypothermia. I don't know.
So I think we had boiled it
pretty
down to
much
like
what I remember.
issues, right? Because there was literally three possible scenarios in this case. One of them was, all right, Karen Reed hit him on purpose. The other one was Karen Reed hit him on accident and doesn't know that she did it. The other one was that he was murdered by the people inside the house and they try to cover it up.
Yes.
And MG Law, I did see that that Chevron has been overturned. But I have not gone into the details of it just yet because I've been so trying to get caught up on this Chevron thing. But maybe we got to do a live on that one pretty soon in the near future. Yeah, that's like a 40-year-old case, a 40-year-old precedent that's been overturned. I got to read into it. I haven't yet. I'm stuck on this Reed thing, and my brain is not that smart to be able to go into two different directions. MG Law, though, he's like this super smart attorney on YouTube. He's a law tuber, I guess. I guess we're law tubers now. He has a channel. He's got about 8,000 subscribers or so. He used to clerk for a judge. He's one of those attorneys that you hate going up against because like they're super quiet and super professional. And you don't know what they're thinking, but they always know their shit. They just know the law. And then you think you hope you know the law as good as they do, but you just don't know because he's got this vibe. And it makes you a little bit nervous. So my least favorite archetype of attorney to go against. I'll tell you who my favorite archetype is. I'll tell you that later. So continuing on. So those three possibilities, right?
Okay.
What I wanted to see was what was the medical injuries. Okay, so he was attacked by a dog and he was murdered. And you're saying that he was hit by a car. Those are the only possibilities. So what does the medical say? There was literally, I think on day 29 or 30 of testimony, that one of the chief medical people from San Bernardino County, no less, was practicing from 1992 to 2017. Anytime, MG, you're a sharp dude, man. He gets up there and testifies and says, yeah, I looked at all the exhibits, I saw the pictures, I saw everything that you sent me, and this was his findings. Number one, had he been struck by a vehicle, O'Keefe been struck by a vehicle at 25 miles per hour, he would have expected to find massive bruising on the area where he was struck, including lower extremity injuries, including other injuries elsewhere in the body that maybe were not directly impacted from the vehicle. And what he found was there was a laceration in the back of the skull, an opening, there was bleeding and multiple fractures in the skull that led to swelling in the brain as it started to bleed into the brain, probably instant unconsciousness. And to him, in his mind, professional, and to me, he was probably the most credible. I mean, I don't want to say the most credible, but he was very credible. It wasn't, look, in order for him to conclude that this was an auto accident, he needed to see other things that he just didn't see. And even on cross-exam, Lally was trying to say, okay, what about this, that, and this? And he's like, okay, yeah, fine. If all those things happen, he's struck by a car. Problem is that didn't happen here. And so I don't know what happened, but the only way that laceration gets on the back of his skull is through blunt force trauma. Could it have been that he struck the asphalt? Maybe. Could it have been that he struck the curb? Maybe. Could it have been that he was struck in the head with a baseball bat? Sure. We don't know the exact mechanism, but these injuries are not consistent with what he's seen, and he had treated hundreds of people. I don't know the exact number that he said, but he's 30 years in, I'd imagine. What it's not consistent with is somebody getting ran over by a car, well, I guess that's it. It wasn't consistent with the prosecution's theory. So that was one. The other thing that was significant is he said that the dog bite marks, of which they didn't find any DNA from the dogs. It was unclear to me whether or not they swabbed O'Keefe on his physical body for DNA from animals, or if they just were looking at his clothes. I just have not seen every second of the trial. I've heard both ways. MG says the injuries to his face and head were from a fight and hitting the back of the head. Yeah, I think there was like a superficial laceration on his eyelid that was telling. But again, you're not going to get a minor superficial laceration from being ran over. You're going to get your face caved in and other stuff. So one of my theories, here's what I think. If I'm putting this together, here's what I think happened. I think he was inside the house. I think that him and Higgins had some kind of a beef. The beef was over Karen Reed. Women or the I don't know, always seem to be the culprit behind these kinds of things. Not always, but in this case, maybe. I don't think that Higgins intended to kill anybody. I think this was accidental. He hit his head on something and then was out cold. And but even that is a stretch, because it's like, okay, did he die instantly? Did anybody know? Would that be the move, or are we calling 911? It just doesn't make sense. But it's more plausible to me that happened versus Karen Reed ran him over, because the injuries just don't fit the prosecution's narrative. Could it have been the case that he was sideswiped?
Yes, I was going to ask that.
Yeah, Karen Reed is really pissed off. And then in the course of being really pissed off, backed up at 25 miles per hour, maybe didn't hit him. And then he took his glass and threw it at the taillight, because there was definitely damage to the taillight that was done. It was definitely cracked, but it wasn't shattered is the problem. And there was video of her backing out of her driveway to go back to the scene where O'Keefe was found that shows that she literally like damaged the taillight in the course of traveling there, which means further damage. Is that definitive evidence that the taillight was not involved? No, because I mean it was cracked. While the car was in custody, the defense showed in their closing arguments, and obviously during the trial, a before and after of the taillight at a certain point in time versus when it was in the custody of law enforcement, and it was just different. Why is it different? That doesn't make any sense unless we're trying to plant stuff. The evidence was presented at odd intervals. You could say that the taillight was possibly shattered, or I'm sorry, the taillight remnants of when it was shattered was hidden in the snow. But then they were using leaf blowers and stuff to like go over this leaf blowers, Ileana. Like think of you're trying to find, these archaeological remnants of something, and they take the a little brush or whatever.
Oh no.
There was a blizzard involved. They're using effing leaf blowers and Safeway bags and red plastic cups to collect evidence. When has that ever happened in a criminal case that you could remember? Roy asks, is Higgins the young kid videoed threatening? No, Higgins is one of the officers that Reed is alleged to have been having some kind of a relationship with, which I think was kind of confirmed in testimony, but that's kind of where it's at. So those are the questions that I had. And to me, after 31 days of evidence and the jury's still in deliberations, I was just kind of mentioning prior to you coming on that it's not all that significant to me that we're still without a verdict, given that there was 2 months of testimony taken in this case, over 80 different witnesses. I think that the jury's just being methodical and going through every single piece of evidence. But what I had suspected was, even if you subscribe to the idea that you have the prosecution has proven that Reed ran him over with the car, which I don't think it's the case at all. You cannot prove, they haven't done anything to prove first degree premeditated murder. So I think first degree is off the table. If you want to say second degree, fine. She was pissed off. She was definitely pissed off. You heard those phone calls, but I don't even think that you get the requisite mens rea for second degree, given that it seemed like she was shouting at him as if he was still alive, given that she had placed 53 phone calls between the time she left and the time she went back to the scene, text message and such. And then there's this odd statement that Lally, that the prosecution, that the Commonwealth keeps harping on. I hit him. But then there's varying versions of it. It's not definitive that she said, I hit him. There's other versions that say, did I hit him? Or maybe she said, I hit him, but like in a questioning, I hit him, like that. I think that, how do you figure out like which is which? I think that you got to look at the way that the investigation was handled on the night of the incident. Nobody treated this as a homicide. In what criminal cases have you ever been involved in where you have a confession at the scene that wasn't immediately locked down as a homicide? That doesn't make any sense. They looked at it as an accident from the beginning, and part of that may have been corroborated by her questioning whether or not she hit him.
And the lady that testified about that is the sister of the owner of the house, the sergeant. So it's pretty convenient that she first said that she said, I think I hit him, and then all of a sudden she changed to I hit him. Like, of course she's gonna be biased.
And that did not come out in any police report. It came out later on in testimony. We were already past, I think, the grand jury when that evidence was, oh, by the way, she said I hit him a bunch of times.
Yeah.
And then it was a thing. But at the time, nobody wrote that in a report. Not one of the law officers wrote that in a report. Not any of the EMT that were interviewed and they testified put that in a report, because the vibe was probably not a confession. The vibe was probably questioning whether or not she did something, which even that doesn't make a lot of sense. If she's questioning it, why wouldn't they not treat it like a homicide anyways? Because she was clearly intoxicated. Well, maybe not at the time. I think that they did the blood draw analysis. They took her blood alcohol. It was somewhere, I think the median level was 0.081.
Okay.
Well, she was intoxicated at 9:30 that morning, which means if her last drink, which I think they stated would have been around 12:30, according to how it came out in evidence, but it was probably much earlier, maybe later, I don't know. And you're talking about the blood alcohol degradation level. That means that she would have been somewhere between 0.13 and 0.29 at the time of the incident. And you can't really get that with any measurable degree of certainty because we don't actually know when her last drink would have been. And so there's that.
Yeah, I remember that we were talking about like they had a lot of drinks in a very short amount of time. So I imagine that they got
it's disputed. It's disputed how much alcohol she actually had. On the video, it's unknown. Like it looks like she's pouring shots into like a tall glass. Maybe she ordered like a water or something, or like a Coke. and then threw shots into it after the fact. There's receipts, but not all of the receipts made it into evidence because of objections.
Okay.
So we don't actually know how much she had consumed. We know they were bar hopping. I know that she had Crohn's disease and MS. And so I'm not sure what her appetite or ability to hold that much liquor would have been. I don't know how that affects it, but it was a thing. Did you know that it came out in evidence that the officers, okay, tell me the problem with this, Ileana, super lawyer in the Inland Empire, rising star on superlawyers.com. What would be your objection to an officer going through a physical cell phone that was collected into evidence well after the arrest to search for anything?
Well, did he have a search warrant for it?
It was an evidence. It was an evidence, and even if they had a search warrant, what would have been the objection? It was already in their possession. There was no need for a warrant.
But why was he like? I don't understand why he's looking for. What is he looking for?
Exactly. So here's the thing: when you have something already in evidence, what always happens? They take a digital copy of it that's redacted for privilege issues. It gets to the attorneys before it ever gets to anybody else. Is the point? So if anybody's going to rely on it, you're going to get a digital copy, because you got to find if there's privileged stuff in there because it was collected after the fact, then it has to be redacted. But this guy literally, and he's like texting back and forth with buddies, is looking for nudes that might be on her phone.
No.
They're like talking very disrespectfully about Miss Reed. They're talking about how, oh, she's a pretty girl, but she has a flat ass and she's leaking poop because of her Crohn's disease. And then at that point, Alan Jackson gets on the stand. Hey, sir, did you know that she's had like 10 surgeries on her lower intestines within the span of like 10 months or something like that? Things that the jury would have never known about, but came out because of how ridiculous that officer was in his testimony. It was really bad. So there's all kinds of there's all kinds of problems with this. You don't have to look hard for reasonable doubt.
Yes.
So I am of the opinion, a couple of days ago, this is what I said. I think that it's 10-2 in favor of full-on acquittal.
Okay.
And the reason I think that is because there isn't been any evidence put on that definitively proves that he was hit by a car. And the most reliable medical evidence suggests that the evidence are not consistent with being hit by a car, but it's consistent with him getting attacked by an animal and being in a fight and hitting the back of his head really hard to lose consciousness. And think about it. They got rid of the dog. I think it was Higgins who his phone was ordered to be turned over to the cops on the 30th. And then on the 29th, he changes phone carriers and deletes a SIM card and cuts it up and disposes of it at a military base.
Of course.
Because at military bases, they're not probably going to go through the garbage looking for evidence. And why would a cop be doing that? He said, oh, because somebody had contacted me about a collateral investigation. And so I was doing my best or whatever, which still, that's not, you don't cut up SIM cards. Cops don't do that.
No.
What's your immediate opinion when somebody starts cutting up SIM cards?
They are hiding evidence.
They're hiding something.
Yeah.
And which hasn't been proven because they're not the ones on trial. The defense doesn't have to prove anything. But it is, if you're looking for reasonable doubt, man, that's another area of low-hanging fruit for the jury to rely upon.
Now, in this case, of course, there's so much going on. It's hard to say what really happened, but something that stood up to me while I was reading about the trial is that the people that were in the party testified that apparently O'Keefe is the guy that passed away. O'Keefe never entered the party. They never saw him inside, but then they left the party, and if he was outside already dead, nobody also saw him. Like, how is that?
McKay was talking about, like, there was this period of time where they were able to finally put in some stuff into the timeline where she was looking for him. She saw the SUV out there. She was going back and forth, and she was looking whether or not he was there. She didn't see him. She didn't see him laying in the yard or laying in the snow or anything. So there was this recreation of well, Julie D says, oh, me and Dominic are clicking on it at the same time. Julie, thank you so much for the 10. She says, watch Higgins on the stand. He is only one who got emotional, especially when he said he asked if he broke video game night before with nephew at O'Keefe's. So does he get drunk, break stuff, and black out often? No, I'd imagine that's not healthy, a healthy lifestyle choice. I know that. So Higgins is the one that it came out in testimony essentially like this. Reed was unhappy in her marriage. She confides through text message to Higgins that she's unhappy. Mm-hmm. And they're sharing their positive affirmations for their physical attractiveness for one another. Mm-hmm. And then at some point, they shared a kiss on the front porch of the home. And so there was some history there. And then Higgins didn't want any drama. He said that. Why is that even important? Because it's possible explanation for why there may have been a beef that escalated very quickly because O'Keefe knew about the thing between Reed and Higgins. So if you're looking for why they're all cops, aren't they supposed to be friends? Well, not if they're fighting over a woman, even an insignificant woman. And I don't know what Higgins thought about Reed. I don't know if he thought about her, like if he was in love with her, if it was like a fling, or if it was like this pissing contest between him and John. Who knows, man? But all it takes is a split second of somebody to push and stumble over something when they're blackout drunk, hit their head and pass out, and everybody freaks out like, what the F just happened? Throw them in the snow. We're going to make it look like an accident. Hey, everybody, I want you, look, this is the game plan. He was never inside the house. We found him in the snow. That's all we know. He goes in a full-on cover-up mode. And then nobody seemed to look. There was a lot of negativity towards Karen Reed amongst those circle of friends. It came out very strongly in the testimony in this trial. Whatever you think about Karen Reed and her quality as a wife, girlfriend, whatever, she was not liked by John's circle of friends all that much. They tolerated her. They hung out at the bar. They got along. Her and John were being very affectionate with each other. And then they're summoned or encouraged to go over to this house. And then, everything else happens. MG Law says that Higgins is also on video at the bar yelling at O'Keefe that night. Yeah, there's that. What I don't know is what was the contents of what he was yelling about. Was he yelling about, hey, Celtics? I don't know.
You were saying that there was a recreation.
Yeah, I was going to go over. So you remember when we did the Murdaugh trials, this person, as Getz, YouTuber, created a 3D reconstruction of the murder. Well, she did the same thing of Reed. And I think she did it of multiple theories of the case. So I'm going to share my screen with you folks. And we're going to take a look of, it's very striking because it's funny when you listen to the testimony, you picture it one way in your mind. In this 3D animation, it makes way more sense of what the prosecution was trying to say, and it gives you some more perspective. So let me just get this on the screen and we could take a look at it together. This one would be...
Recreations are always helpful.
Yeah. I just want to make sure that I get the right thing on here. I'm so used to OBS. I keep looking at the wrong thing. All right, Karen.
I like this setting, by the way.
Oh, you like this better than Zoom, you mean?
Yes, definitely.
Or the other nonsense that we've tried to do in the past?
Yes.
Okay, so here is this video. It's about 1:52 long.
Okay.
But this lady, as Get, she's really good at this stuff. Go check her out and give her a follow if you haven't already. This is from her channel. I'm going to just play it.
Of the Karen Reed murder scene. A special thanks to Emily at True Crime for bringing this to my attention. If you like my work, please follow. The time is around 12:30 a.m., and Karen Reed sits in her car approximately 60 feet past the home where John O'Keefe's body was found. This is based on the prosecutor's opening statements that Karen Reed's vehicle traveled 60 feet in reverse at 24 miles an hour when hitting John O'Keefe. Karen leaves and drives back to O'Keefe's house, where she goes to bed for the night. Supporters of Karen Reed questioned these events. One thing is, it's reported his cell phone was found under his body instead of being thrown in a different direction.
Look at that.
Reed's vehicle traveled 60 feet in reverse at 24 miles an hour when hitting John O'Keefe. Karen leaves and drives back to O'Keefe's house, where she goes to bed for the night. Supporters of Karen Read questioned these events. One thing is, it's reported his cell phone was found under his body instead of being thrown in a different direction. Other things that don't make sense is how someone being so far down the road would stop, back up quickly with the intent of hitting someone, and then that person would just stand there and not get out of the way.
Unless he couldn't move because he was black.
For me, one of the biggest questions is how it is possible that no one witnessed this. This wasn't some quiet night and everybody was in bed. There was nearly a dozen people in the home having a party. That's why Karen and John were there in the first place. Jennifer McCabe testified that she could see Karen Read's car out front the door and that she was texting O'Keefe to park behind her car. Viewing this from another direction, you can see how Brian Higgins' Jeep is parked right in front of the mailbox. And as we move in and view this from the driveway, it seems unlikely that 12 people would leave the house and not have been able to see a body in the front yard. Also, this was a night that it was snowing, and I wonder how Karen was able to accelerate so quickly without just spinning tires and warning O'Keefe of the impending danger. Thank you for watching.
I don't remember how the accident reconstruction evidence came out about how she was able to accelerate in icy conditions like that in a blizzard in the span of 60 feet, which is really not that long. I don't know if you're a baseball fan, Eliana. That's literally the distance between the pitching mound and home plate. It's not very far at all. But yeah. I have, when I was living in the Midwest and I had to drive in the snow, I'm not accelerating with any effectiveness to, well, I guess 25 is not that fast. I guess maybe it's possible. I don't know. I just don't remember how the what the video or the car data was on that. But if you look at the just the layout of the scene, to be fair, I think it's plausible that people in the house are not going to notice that on a dark night in the snow, blizzard conditions. I would miss that. I just would. When I look outside the window, I don't normally look at the grass. So if there's anything laying in there, if it's not obvious, and look, if this is off kilter to the window right there, I'm not looking this way. But McCabe said she was looking outside. She saw the SUV over here in, I guess, the general direction of where he would have been, and she didn't see him.
Yes.
So, not forget. So there's that. And then she did another one. Let's take a look. Make sure I get the right thing on screen. All right, so there's that one, and now there's this one.
Please follow if you like my work. This is the home where the Karen Read incident took place. Karen stated in her interviews that after arriving at 12:24 a.m., John got out of her vehicle and was going into the home to check things out. Walking up the driveway, he approached the door nearest to the garage. After entering the home, you realize it would be impossible to walk through to the basement and not be seen.
Yeah.
Jennifer McCabe testified that she and others were sitting at the kitchen table, and that periodically was getting up and going to the front door. Here's an illustration of what you might see from the front door if John's body was there at this time. Continuing, we approach the stairs leading to the basement. This leads to the weight room where the defense believes John O'Keefe was attacked. It's assumed that they used this door, which leads to the backyard, to remove John's body from the basement to outside, where no one upstairs would be able to see. They then continue to the side of the house, through the gate, which leads to the side of the house with the flagpole.
Hey, what is that noise? Do you hear that little pump action? Oh, never mind.
Those were pumps that just stopped.
Like, what is that?
Sorry.
Okay, of those two scenarios, which do you think is the most plausible?
That second one, definitely.
Look, I mean, again, it hasn't been proven, but when you got dozens of butt dials amongst a group text chat, and you have people all trying to say, oh, he never came into the house, but you have Apple data that says otherwise. And when you have medical evidence that doesn't fit the or correlate with a theory of him being hit by a car, it makes a lot more sense that, look, there was some kind of a scuffle in the basement, or maybe they took it downstairs. There's weights in there. You know, those are not soft objects. I mean, you're inside a house. They had the means and the wherewithal to take him back out from the back, around the gate to the front where he would have found him and just left him there. And then they were going to say, I don't know what happened. We just found him. I don't know. Of the two theories of plausibility, in terms of plausibility, it just seems more likely that the defense theory makes more sense because it just fits the injuries better. But again, you don't have, I mean, you're not, and they're not the ones on trial. You can't prove it. It's not perfect evidence. I can't really say that anybody, I'm frustrated with this case, man. Nobody's.
I know. Me too.
Because it just as much as it doesn't make sense that he was hit by a car, it just doesn't make sense that they would get in a fight and then, you know, dies instantly, because it's different. Like, okay, because if he just slipped and fell and hit his head, I mean, you could just say, oh, he was blackout drunk, and so we called 911 and whatever. He didn't remember what he was doing. But I don't know. Maybe there was like motive for like maybe there was an actual attempted murder. Who knows, man? There's all these wild theories.
I think that's I agree with you. That's the most frustrating part, because neither story makes sense. Like, none of them. There's just not enough evidence, or there's evidence against each of the scenarios. So, I mean,
the FBI has stated in their ancillary report that O'Keefe was not hit by Reed's SUV.
Okay.
In their collateral investigation and all of this. What does that mean? It just means, I mean, well, it doesn't mean anything. All I'm saying is reasonable doubt is the standard. It's the highest standard in law, basically.
In law, yeah.
Right. And so if you're looking for reasonable doubt, and the fact that we're even talking about these alternate theories being more plausible than the prosecution's theory, that's a reasonable doubt issue. And so I think more than, so if you go back to that first video where she's backing up, I just think it's more plausible. Look, I think the prosecution could have presented this as a theory. He backed up really fast, and no, she didn't hit John O'Keefe, but maybe he fell in the context of that because he was throwing a whiskey glass or whatever at the tail light, and he struck the tail light, and he fell and hit his head and passed away from the but even that doesn't really fit the narrative, because the doctor came in and said that whatever injuries he sustained on his arms that were consistent with dog bites that he treated in the past, and part of his expertise was, oh yeah, I've definitely treated dog bites, and they were very consistent with what I saw with Mr. O'Keefe.
Okay.
He said that he's treated fatal dog injuries, more specifically with small children. And he said those injuries would usually be deep puncture wounds in the neck area leading to death. But, you know, more commonly on a dog attack, he would see the kinds of injuries that were consistent with what he found on the arms. And all of those injuries were occurred while he was still alive for medical reasons. Now, unless you want to say that there was some animal that came by and started gnawing at his arm, maybe it was a raccoon, maybe it was a coyote or something, starts gnawing at his arm and he's laying there still alive but unconscious, I guess maybe that fits. But
maybe, but then at the same time, with the blizzard, animals tend to hide, so I don't think that many animals will be in that outside.
Is that a fact? I don't have any. I haven't lived through many blizzards. Well, I haven't lived through any blizzards, I will say that. I live in Columbus, Ohio. It doesn't really snow that much. I mean, it snows enough to like give you a taste of it, but you're not going to get like
one.
Boston.
I went through one in Kansas once. My husband at one point was working in Kansas when we moved to the States, and we went through one outside. I mean, there's the little bunnies. I don't remember.
We may have breaking news. Let me just confirm.
Oh, they're hung?
I think that the jury might be trying to tell the judge that they got issues.
Yes, I see it there. Miss Ann said that they're hung at this point.
I haven't confirmed that anywhere. Well, you know what? Let me break into the live feed and see if they are. Oh, yeah. CBS is reporting it right now. They say that they're deadlocked and judge sends them back. Let me just break into this real quick, and then we'll give our thoughts. So they're not hung officially. They're stuck on an issue. All right, let me share my screen. It's going to be this one. Present. Yeah. All right.
Yeah, I'm reading the comments that apparently they were hung, but the judge said,
yeah.
It's
yeah, we're not. You're going to have to try harder. But let's listen to the first part of this.
Earlier this week, they've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted.
Disagree with Mr. Lally's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there.
Okay. All right. So you all know that it is within my discretion. I decide. So a case that has been, it's a long case. This is our 4th day of deliberation, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
Yeah, good on the judge.
Yes.
All right, so that's that. So there, if I might just motion to break for the weekend at this point. Like give them a few days. I mean, I don't know, man. It's been 2 months of trial, and now they're sitting here. They're going back over all of this stuff. The brains are fried, man. They need a day to beach or something. Get them some drinks. Give them an edible. Give them some shrooms. Let everybody just kind of reset. But yeah, jury deliberations are exhausting.
They are. And in a case like this, where the evidence is so all over the place and the stories don't make sense, it can lead for the jurors to say, you know what, I give up. I don't want to try this anymore, and say we cannot reach a decision. So
the best movie I've ever seen that perfectly captures what deliberations are like is 12 Angry Men. And I'm not talking about the 90s version. The one, you got to go all the way back to the 50s, the old one, the black and white. That's when they start off, it's 11-1 in favor of guilty, and then through exhaustive deliberations, of course, over the course of like one day in the movie, but you kind of get the feeling. The AC is out, the fan's not working, or they got a fan, but everybody's annoying and everybody's arguing and bickering back and forth. Some guy just wants to get the hell out of there because he wants to get to the Yankees game. He's got these tickets he's been holding on. But there's one holdout is like, well, wait a minute, let's just go back over all the evidence. And then slowly but surely he starts turning over every juror. It's like, all right, maybe the kid's not guilty. And at the end of it, they do this great thing.
I don't remember if I watched that movie, But I do remember that my torts professor in law school had us watch a black and white movie and do a report on it. So I wonder if it was that one. I just can't remember what it was.
It probably was. I mean, I don't want to get copyrighted or anything, but I'm gonna show you the one that I mean. Maybe you can find it. Yeah, it's this one. This one. This is the one. Here, let me share my screen with you. Tell me if you recognize this. F. All right. You recognize this on screen? 12 Angry Men, the black and white version. It had I can't even remember the names of the actors.
I mean,
What's this one? This version.
I sincerely don't remember. It's been too many years, and I remember watching it late at night. Like I didn't want to, but what I remember it was black and white, and this professor, he was known for like making us watch famous movies that made sense about I guess legal world. So
Well, did it make sense? Did it help?
I think it did. It was my first
Henry
year.
Fonda, that's
It was first semester, first year of law school, so my mind was just everywhere.
In law school, man.
Yeah, so that's why I don't remember much, but I think it must have been that one because this is something that kind of goes with how this professor was. So I really like him.
Yeah, so the jury is fried, man. It's a lot to go over, and some of them have clearly dug in their heels on things. I'm very curious as to what that would have been. Maybe they're deliberating between involuntary and second degree. Somebody had sent me, let me see if I can get it on screen. The deliberation forms that they were given, which was problematic for a number of reasons. I didn't mean to go into this one. But the deliberation forms that they have are kind of nonsensical. I mean, they're not that complicated, but there was some objection by the defense because the boxes, they didn't have a box that you could check indicating that she was not guilty. And then the judge is like, well, then they just don't have to check the box. How about that? Let me get this up on screen. So this was the what they are working under right here. I'm in the Discord. This is the verdict slip, and you can see these are their options. 1, not guilty. 2, guilty of offense as charged, manslaughter while operating a motor vehicle under the influence. There's manslaughter while operating a motor vehicle, manslaughter while operating a motor vehicle with blood alcohol of 0.08 or greater. Guilty of the lesser offense, guilty of the lesser included charge. I mean, I don't inherently see anything really particularly wrong with these jury instructions. It's a little bit too small. I can't really see.
It's his job to try everything, so he's of course going to object on it.
I feel like the first, I don't know, is this an updated jury slip? This was, somebody dropped this off in the Discord. I feel like the first one that I saw did not have this not guilty checkbox on there.
From what I read, he objected about the that sheet. The judge initially was like, "No, this is how it is," and then she ended up giving a revised version with additional instructions to the jury. So this could be the revised one.
Okay, yeah, I was gonna say, hey, that's not what I just said at all. There was not a box for not guilty, and now they just added it. The judge is trying to say that all they got to do is just not check the box that says guilty, and then all know what they mean.
Judge is making sure that there's no mistake in how this is like through the trial.
It would be a disaster if this ended up in a mistrial. Could you imagine
having to go through all this again? Oh no.
Trial. What do you think? What are the odds that this gets retried in the event of a mistrial?
I don't know. I think it will depend on whether or not any new evidence about the alleged I guess conspiracy comes up. Because as far as like the trial itself, I haven't seen anything.
There was a collateral investigation by the FBI. Now, look, this is a state case, but to the extent that the feds get involved, they're not going to interfere with the state's case.
Of course.
But why they've done this collateral investigation is to look for some kind of malfeasance by law enforcement, I'd imagine. So regardless of what happens at trial, I think if the FBI has concluded that these officers were trying to plant evidence, that there's going to be a federal investigation or case brought against law enforcement. Potentially, I could only imagine, why else would they be investigating it? They've made findings that are inconsistent with the state's case. I don't know if they've published all of their reports, but I got to imagine that they're trying to gear up towards a potential federal prosecution of law enforcement over there, to the extent that they find that was more likely than not. But if that were the case, I feel like they'd move rather quickly. I don't know why they would wait till the end of the trial, but that's their deal. But they're not going to interfere with this criminal case with Karen Reed. But what they are looking at is the malfeasance of law enforcement, of which there's a lot to look at over there. But yeah, if this jury hangs, I do not see this getting retried. There's too many resources. There's too much scrutiny. I think they just leave it alone at this point. It'd be the rare case where I think they would just like, you know what? This shouldn't have been brought as a first degree case anyway. They haven't shown any evidence that there was some kind of premeditated plan prior to her getting pissed off at O'Keefe after midnight that day that would have lent itself to first degree murder. And we were saying that before.
Did she end up getting charged with first degree? Because I thought it was just second degree that she got charged with.
She's charged for first, second, involuntary manslaughter, and there's the lesser.
Second and involuntary manslaughter. That I remember. I don't remember the first one, the first degree.
I don't even just look at the jury slips. The jury slip, it specifically says guilty of offense as charged, manslaughter while operating a motor vehicle under the influence, manslaughter while operating, guilty of lesser included involuntary manslaughter, guilty of lesser included motor vehicle homicide. So those are the options, or she's not guilty of those things. But you're right. I don't see first degree as a charged thing. Manslaughter while operating a motor vehicle under the influence is not first degree murder.
No.
And it's not even really second degree murder. So there's been some revision here. But they initially brought it as a first degree case, which, you know, why would they do that to begin with? But they did. But this verdict slip makes a lot more sense, given what we've seen in the case, because it's not a first degree case. And I'm not even sure you could make a second degree case. This is a murder, if anything, if at all, under the context of driving a motor vehicle. And there's no evidence to indicate whatsoever that she knew that she hit him if she did. There's not even any evidence to indicate that she actually ran him over with the car, because the evidence is not consistent.
Oh my.
I mean, if you wanted to charge her with the DUI, they could have done that at the scene. They could have done a breathalyzer at the scene and probably found that she was still over the legal limit, you know, at 5 a.m. or 6 a.m. in the morning, whenever that happened.
That's crazy.
So I don't know. I don't see this being retried, but if the jury hangs, that would just be such a disaster. That would be such an anticlimactic disappointing outcome. I do wonder what the holdup is, though, because to me, I don't know. If the holdup cannot be whether or not she was hit by a car or not. That can't be what they're arguing about. Let's go through some of this. Let's do a recap of what the jury has seen over the course of all of this evidence. So remember, day one, there was opening statements. They took testimony from O'Keefe's brother. And he said things. On day two, the defense was challenging police credibility in the early stages of the investigation. They talked about Canton police officers, firefighters, EMTs who responded to the scene. They testified, and this was really the first witnesses. And my question to them was, why would they start there? Firefighters, EMTs, those are usually middle of the trial witnesses. You usually start with like, okay, well, who was like the lead person? You know, you start with your most important witness because it gets into the minds of the jury and frames how they are absorbing the evidence going forward. But they start with like these mundane secondhand investigators. They called two witnesses who said that they heard Reed confess at the scene after O'Keefe was found in a snowbank. and that was going back to the I hit him thing. But then, as we had talked about, that could have been with an inflection. That could have been, did I hit him? It could have been, other things. But that doesn't really hold, because if they did hear that, nobody treated it as if it was a homicide investigation. Jackson was questioning one of the people who said about an admission, and he was saying that it was not in his police report. So you're saying that you heard her say, I hit him. And why was it not in your police report, dipshit?
That's
that
a big
seems like a pretty important fact to omit. Wouldn't you agree? And they did that whole thing. Going into day 3, they were talking about, again, more about Karen Reed's statements. They had Anthony Flamati. He gets up on the stand, and then he tells the jury about the care he and his team provided O'Keefe. They talk about a conversation he had with Reed at the scene. He had confirmed prior testimony from other prosecution witnesses about the confession allegedly made, but Jackson comes back and he hits back at that again and says, but your report about the incident did not include that confession, right? Right. So why the F are you telling us about this now? Why would that not make its way into your report? Because that seems to be a fact that may or may not be dispositive as to what happened here. They had Katie McLaughlin get on the stand talking about Reed was very upset, and that was supported by some of the video evidence that came in. The dash cam footage, it showed that Reed was just kind of acting like it wasn't as bad as what she seemed like. She wasn't like a raving maniac, but she was definitely upset.
Okay.
Visibly distraught was the word that he used. She also testified that she heard that Reed said, I hit him.
Okay.
And again, this is day 3 of testimony, because around day 21, 22, or actually 15 or 16 with McCabe, you start to hear, well, actually, maybe it didn't come out that way. It came out a different way. Also that morning, there was a decision by the judge to institute a buffer zone around the courthouse because there was all kinds of stuff going on outside of the courthouse. So on day 4, the jurors actually take a tour of the scene. They viewed Reed's SUV. And then on day 5, do you remember this one? This was one of the first oh shit moments in this case. Before we started getting involved with this Eckerd nonsense. Let me get to it before I mess something up. Oh, Karen, okay. No. Oh, okay. I could do it like that. Right. Yeah, tell me if you remember this.
Calls that morning. The first saying that Karen Reed was freaking out because her boyfriend, John O'Keefe, had not come home that night. And then the second saying that Reed and 2 other women had just found O'Keefe's body lying in a snowbank. Now in court, O'Keefe's family, they wiped away tears as that second 911 call was played for the jury. Karen Reed, she stared straight ahead. The woman on the phone in the call, she asked the police to send an ambulance as soon as possible. And the dispatcher asked if the man in the snow is still breathing.
This evidence that was collected in these red Solo cups in this paper grocery bag or whatever, and everyone's like, wait a minute, this was a criminal investigation. You're collecting evidence in the scene, and the way that you chose to collect the evidence was through red Solo cups in this brown paper bag. And we're like, what universe are we living in over here?
Officers described how they borrowed red plastic cups from a neighbor to collect samples of blood in the snow, and then took them back to the Canton police station in a Stop and Shop paper bag. Officers say they didn't have anything else to collect the evidence, and so they had to improvise. The defense asked one of the officers if perhaps that created an opportunity for evidence tampering, but the prosecution objected, the judge agreed, and that question was never answered today in court. 2 911 calls that morning. The first.
All right with that. Yeah, that was kind of the first. And like indication that something is screwy over there in Massachusetts. So they had that. Let me go back to my notes. My notes are kind of all over the place. All right, so that was day 5. On day 6, they talked about evidence that they found in the snow. There was a half day of testimony featuring law enforcement witnesses. Prosecutors appear to be developing an argument that O'Keefe was holding the glass when he was hit by Reed's SUV. So far, no one at that point had suggested when or how Reed's taillight was broken. But a video shown on Tuesday on that day, on day 6, began to address that question for the jury. Officer Lank was cross-examined about his relationship with Brian Albert, who owns the property where O'Keefe was found. He described their relationship as civil, but also confirmed that he intervened in a 2002 fight on behalf of Brian's brother, which, you know, if you're talking about men, I mean, that's 21 years ago. I don't find that all that significant. Water under the bridge at that point. On day 7, they talked, jurors were shown footage of the two inside the bar, and you could see them just kind of being really lovey-dovey in the context of everything. Play that video for you right now.
O'Keefe gave each other a hug and kiss at C.F. McCarthy's pub in Canton that night in 2022.
There didn't seem to be any tension between them and C.F. McCarthy's. Is that right?
Not that I recall.
The prosecution has said the couple argued that night and that Reed ended up backing into O'Keefe with her SUV. But witness after witness who testified say they saw no trouble, not at C.F. McCarthy's and not at another bar called the Waterfall, where O'Keefe and Reed went next.
It seemed like they were like quite lovey-dovey at that point.
In fact, she says Reed kept praising O'Keefe for taking responsibility for his orphaned niece and nephew.
She also wished that some of the family members would step up and help out a little bit more because he took all the burden on himself.
Also at the Waterfall that night, Brian Albert and Brian Higgins. The defense has claimed they were part of a cover-up in O'Keefe's death. In the video, Albert and Higgins seem to be play fighting. The video also shows O'Keefe and Reed leaving the Waterfall bar. As they do, O'Keefe appears to have something in his hand. The day before, in court, prosecutors showed a partially shattered glass found next to O'Keefe's body. And prosecutors are laying out the case that O'Keefe was holding.
How often have you ever left a bar with one of their glasses in your hand and just made off? Man.
Never, but I have a funny story where my dad and also my now husband, which he learned through my dad, when we would go to restaurants and I was, I guess, talking, doing something else, they would put the cutlery, like the knife, spoons, forks in my purse. And I will leave the restaurant and I didn't know. And then once I will get to the house or open my purse, I will find all that. But it was not on purpose. But with my hand, I mean, most of the time, the restaurant or the place won't let you leave the property with their glass with their glasses, and not even with the drink in hand. There's signs that do not leave this property with alcoholic drinks, even if it's in a plastic container. So,
Cat Lady says that sometimes my significant other and I are lovey-dovey, and sometimes I'm smashing a pie on his car, a cupcake on his car. Welcome to relationship. Yeah, I guess that's true. Sometimes when couples are angry at each other and they get outside, they're like aggressively lovey-dovey with each other because they're mad, but they're wanting to have a good time, but they're doing like aggressively. I don't know, man. Relationships are complicated.
They are.
Hey, so did you give all that cutlery back that you stole from the restaurants?
No, I was so ashamed to go back. But it was a thing, and they would just tell each other, like, look what I did. I was so embarrassed. I just started paying more attention to my purse before leaving restaurants whenever I was with them.
Oh, goodness. My family usually plays different jokes on each other. It's certainly not that. They'll jump like a whole half a bottle of Tabasco sauce in your hamburger or something.
Oh, okay, yeah.
All right, so that was day 8. Well, on day 8, there was neighbors that testified about the night of the death. There was Chris and Julie Albert, O'Keefe's neighbors. There are also relatives of the family that owns the home outside which O'Keefe was found. Albert owns a pizza restaurant in Canton. He said he was at the bar with Reed and O'Keefe on the night in question, but not at the after party. Albert's son, Colin, was at the party, and the defense questioned him extensively about when Colin returned home. The defense appears to be suggesting there was tension between the Alberts and O'Keefe. They didn't really get much farther than that. On day 9, the owners of the home, the Alberts, testified about where O'Keefe was found. So Nicole and Brian Albert, they owned the home at 34 Fairview Road and were part of the group that was out drinking with O'Keefe and Reed. Several people were invited back to the Alberts home after leaving the bars, but they testified that neither O'Keefe nor Reed ever showed up. The defense also asked about the decision to rehouse their dog, which is, so what'd you get rid of the dog for? I think that they had owned for like 7 years or something like that, which Nicole Albert said was made after an incident in 2022. Testimony was interrupted when the prosecution asked the judge to remove controversial blogger Turtle Boy from the courtroom. And he was he's facing other charges. And after arguments, judge determined that he would be excused from the courtroom, and that was that. So day 10, the Albert family is back on the stand. They are being cross-examined. Several people were invited back to the Alberts home after leaving Canton bars, but the Alberts testified that neither O'Keefe nor Reed ever showed up. Mm-hmm. Brian Albert said that O'Keefe and Reed would have been welcomed with open arms if they ever did come inside. Brian Albert Jr., who was celebrating his 23rd birthday on the night in question, testified that he saw a black SUV outside the home. At first, it was near the mailbox, and later he said he saw it near the flagpole. And then there was pictures of that were presented.
But they never saw the body,
No, they never saw the body until obviously much later. So on cross-exam, Caitlin faced questions about her relationship with Katie McLaughlin, one of the EMTs who arrived at the scene after O'Keefe was found. Did you remember that whole thing? She said they went to school together and have mutual friends, but never spent time one-on-one. I think there was some indication that they had never met or had any kind of a relationship. And so that was a thing. It wasn't a big thing, but it was a thing at the time. When the jury was excused, defense attorney Yannetti told the judge he plans to show McLaughlin his bias through pictures of her with Caitlin Albert and others. I think they were from like a yearbook or something. And then I think you and I had even talked about, hey, so of all the pictures in your yearbook, if you were to meet them now, 20 years later, or 30 years later, however long it's been, would you remember them? No, not even a little bit.
Maybe 10 of them, because they have very peculiar faces. Other than that, no, you're,
one of my best friends in high school,
mm-hmm.
I recently saw, she looked a certain way in high school. She was one of my best friends. She was a lesbian, like a very famous one. Mm-hmm. And she was like part of her whole deal, personality, comedian and whatnot. She had a very distinct look, but if I saw her now, she looks completely different, almost unrecognizable. Well, I guess I could probably recognize her, but that's like one exception. Everybody else, I mean, it's been 20, 30 years, man. If I knew you back then, I don't know you now. And so it was a big nothing burger over that. So day 11, the Albert family friend testified about the black object in the snow. So Julie Nagel, a friend of Brian Albert, whose parents owned the Canton home, was at a residence with several friends drinking and dancing at a party. Nagel and her friend Sarah Levinson left the party with Matthew and Jennifer McCabe. She said as they were leaving the Alberts home, she saw a black object that was about 5 or 6 feet in length on the lawn. Defense attorney Yannetti asked why it was the first time she discussed the size of the object. Which, that's, unless you're directly asked that question, I'd imagine that you wouldn't just blurt that out. Oh, I definitely see this black object. It's about 6 feet tall, or maybe you would. I don't know.
No.
It just would not be top of mind, but I could see why somebody would omit that information. On day 12, they began emotional testimony. There was a key witness, Colin Albert. He was one of 3 people the defense tried to implicate in O'Keefe's death. He began his testimony during the final hour of court on Wednesday. around that day. He was in high school at the time, but testified that he was drinking a beer at a friend's house before going to 34 Fairview to celebrate his cousin's birthday. He said he spent about 90 minutes there before texting Allie McCabe for a ride and leaving around 12:10. Said he never saw O'Keefe on the night in question and testified that they had no animosity or arguments. So, look, the other problem with the defense's theory, even though to me it makes more sense than the prosecution's theory, is that not all of the people that were there in the house had beef with John. No reason to be involved in a cover-up. So if there was a cover-up, it was amongst, just a few people, maybe a few of the officers, maybe Higgins and somebody else. But you saw in that 3D reconstruction, you can't really go into that house and go all the way down to the basement without running into people. And they all would have been congregating right there in the living room, right next to the window. And so nobody testified that he was ever inside the house. The only person or entity that testified that it was inside the house was the Apple cell phone data. How was that?
Yeah.
So I don't know what to make of that other than to say you don't have any eyewitness testimony corroborating the fact that O'Keefe was in the house. Does that mean anything? Maybe, maybe not, but it's something. So on day 13, the defense confronts Colin. So one of the people that Reed's defense had tried to implicate, he started his testimony talking about Colin. He returned for cross-examination, and he faced confrontational questioning about photos, videos, whether he had been in a fight. Defense entered into evidence a photo of Albert taken less than a month after O'Keefe's death. In the image, the knuckles on his right hand are bruised. The defense was basically trying to convince the jury that John was beaten and argues that Colin Albert had been in a fight. And so, ipso facto, Albert did see him there and got in a fight, and perhaps it led to Mr. O'Keefe's death. Albert said the injury came when he fell in a driveway, that he never saw O'Keefe on the night in question. I don't know. And all the times that I've ever fallen in the driveway, but when I've fallen, period, the bruises or injuries I had were never on my knuckles.
I know, it's like you're gonna fall, and then your instinct is just to put your knuckles like.
Well, you're putting your hand out to brace yourself. You're more likely to sprain a wrist that way. You're certainly not going to brace yourself with your knuckles.
No, it doesn't make sense.
Not how that goes. So it's fishy. On day 14, there was a video evidence. There was a video entered in evidence. Jennifer McCabe, she gets on. So this is the first. She was on the stand for like a couple of days. So she gets on the stand. Her husband, Matt McCabe, they both testified that they had seen Reed's black SUV outside 34 Fairview. During McCabe's testimony, prosecution showed a message that she sent to O'Keefe asking here, as in she was expecting him to be there. The Albert family previously testified that neither O'Keefe nor Reed ever came inside. The McCabes and Reed was hysterical the next morning. McCabe said Reed told her O'Keefe hadn't come home, they hadn't gotten into a fight, and that she'd left him at a bar. McCabe eventually drove to Fairview in Reed's SUV. She said that Reed spotted O'Keefe in the snow before anyone else and repeatedly made incriminating statements. Again, did I hit him? Could I have hit him? McCabe said Reed asked several times that morning those questions. She also said that Reed told the paramedics that I did hit him. So McCabe's testimony was varying forms of I hit him, I didn't hit him, questioning whether or not she hit him, all of these things. So there's a lot going on. And then on day 15, she's facing cross-examination, and it got a little testy with Jackson. So Jackson questioned her aggressively about her account of what happened. McCabe said that I can tell you today with 100% clarity, he said, I hit him, I hit him, I hit him. Which if I've been doing this long enough that when somebody says that on the stand, I can tell you with 100% certainty I hit him. It's been something that's been floating around in their brain and they have settled in on answer. It's really not all that reliable. There's been multiple times when people have made similar statements like that, and then I'll show them like a text message is like, oh, but you said you're 100% certain, right? So, but this text message says the opposite. What do you make of that? Oh, well, I guess I just don't have perfect recollection. Okay. So let's not ever make the mistake again that you are 100% clear on anything here in this case. Oh, All right, continuing on. So day 16, there was confrontations over the phone records. Fiery cross-examination of Jennifer McCabe continues, who was at the bars, the house party, and with Reed when O'Keefe was found. It finally finished that day. She clashed several times with Jackson, who questioned her aggressively about her account of what happened on the night of January 28th and the following morning. They sparred over McCabe's phone records and the timing of an internet search for the infamous Hoss Long to die in cold. Look, if you take that text message in a vacuum, it's not an incriminating text message.
Mhm.
If I saw somebody lying in the snow after I had gone to like check for vitals and stuff like that, I may text, hey, how long does it take to die in the cold? If I know it's been obvious he's been laying there for a long time.
Yeah.
But question, the defense was implying would show that McCabe knew O'Keefe was outside hours before he was found. McCabe says Reed asked her to do that search, which you and I had talked about that before. That doesn't make sense. I'm not asking you to text anything. I'd much more readily call 911 and have them get their asses down there. And there was also testimony that Reed was lying on top of O'Keefe to try to warm his body, I guess. But McCabe said that Reed asked her to do that search after O'Keefe's body was found, but Jackson pushed back on that. He said that McCabe did the search hours earlier and then deleted it from her phone. And then Jackson asked her, did you delete that search because you knew that you would be implicated in John O'Keefe's death if that search was found on your phone? And then she said, I did not delete the search. I had never made that search at 2:23. I never would have let John O'Keefe out in the cold to die because he was a friend that I loved. She is such an effing liar. That's my take.
Yes, her and the brother too.
Now, I don't know if she's a liar or not. Well, no, that's not what I meant. I don't know if she's guilty of his murder or not. But one thing I'm quite certain on, I think she's lying.
I agree.
We continue. Day 17. This is when we get Higgins on the stand. The ATF agent, he testified about his relationships with O'Keefe and Karen Reed. He said that Reed had kissed him and testified at length about flirty text messages between the two of them. Reed told him that he was hot. And then Higgins replied, are you serious or messing with me? Haha. Or whatever. I don't know, what would be an appropriate emoji for that text exchange? Really? Oh, shucks. I don't know. Defense attorney Alan Jackson started his cross-exam by questioning Higgins about his romantic interest in Reed. And then Higgins said, I was physically attracted to her, yes. And then during the afternoon session, Higgins was cross-examined by Jackson about his phone records and movements within the Canton Police Department. Jackson sought to imply that Higgins had conversations with Brian Albert hours before O'Keefe's body was found and suggests that Higgins had access to Reed's SUV and other evidence. This is not even getting to any. Look, the interesting thing about this is we've heard you're hearing all of these witnesses, but you haven't heard any medical experts come in yet at this point, 17 days in a trial, to testify what happened to O'Keefe. Because it would have been really helpful if you would have had some kind of medical doctor come in and say that, look, O'Keefe was found. He was determined to have been deceased by way of blunt force trauma that resulted from a car accident. And this is the reasons I know that. And then you would proceed from there. But they didn't start with that. I suspect because they didn't have any evidence. Well, I don't have to suspect. They did not have any evidence that said that. It didn't come out until like the very end. Some kind of explanation as to O'Keefe's injuries and the cause of death. And none of them were consistent with he was ran over by a car. So a lot of this is like, hey, what was the circumstances leading into it? What was the relationships by the two? It's like we're telling like the slowest nonsensical story ever. And there's flirty text messages, and then there's deleted searches. There's Google searches. We found him in the cold, but there's nothing to definitively state he was found passed away, and this was the medical reason for his death and injuries and blah blah blah. Nothing. And this is like 17 days in a trial. So day 18, they get O'Keefe's niece and nephew on to testify, which I don't think the cameras were in there for that one, but what they essentially testified about was how O'Keefe took custody of his nephew and niece after their parents died. The children testified for the prosecution and described yelling and arguments between O'Keefe and Reed, which if you're not going to get her for first degree murder, who cares? Other than to say they have a rocky relationship, I think you got the voicemails to indicate she was really pissed at him.
I think that was unnecessary to involve children for that purpose. Like,
I agree. I think a lot of what the prosecution has presented thus far is unnecessary, and has caused unnecessary delay in this case. But the children, they described an incident where O'Keefe asked Reed to leave the house, and she refused. She said no. She was swearing. She got very loud. But again, who gives a shit? This has nothing to do with the incident. The night O'Keefe died, the niece was home alone and remembered being awakened by Reed at 4:30 a.m. She said Reed shook her, left, and came back and told her to call O'Keefe. And she said she was just pacing down the hallway, asking what could have happened. She said, maybe I did something. Maybe a snowplow hit him. But to me, how does that testimony help the prosecution's case? Let's put on our lawyer hats for a minute. Why would you bring in niece and nephew to say that? That I was awoken by Reed at 4:30 in the morning, and she was giving all of these varying reasons as to why O'Keefe was missing. Did I hit him? Did a snowplow hit him? What happened? That indicates that does not to me indicate consciousness of guilt. It indicates consciousness of where the F is O'Keefe.
Exactly.
And maybe a lack of knowledge, and maybe a lack of perfect recollection of what happened because she was so intoxicated. To what degree, we don't know for sure. Anyway, that's what they did. That was perhaps a regrettable witness for the prosecution. So finally, on day 19, the car and the crime evidence are introduced, and then we have these pictures. The testimony indicated that the tail light of Reed's SUV was broken and that pieces of red and clear plastic were found in the snow. And the defense suggested that corrupt investigators planted the evidence. There was a state crime lab analyst who testified about the damage to Reed's SUV. The damage included a smashed taillight, scratches, and a singular strand of human hair. Maureen Hartnett was the crime lab analyst. She examined O'Keefe's sweatshirt, and this is the one that kind of struck me. I think this was it, where she said she examined his sweatshirt that he wore the night before while drinking with Reed. She said she found red-brown stains and 13 rips and tears, particularly on the right sleeve. Prosecutors argue that the sweatshirt was torn and O'Keefe's arm injured when he was allegedly hit and knocked to the ground by Reed's SUV, which the medical doctor said that's nonsense. Because the injuries on his arm, sweatshirt or not, there was those scratches. And he said those were consistent with like abrasions, and abrasions by its very nature requires friction. It's not just a singular whack with a vehicle. It's literally friction against the skin that causes those abrasions or cuts or perhaps claw marks from an animal, maybe. Prosecutors argue, they argued that. So that came out on day 19. On day 20th, jurors like, okay, now they get to see some physical evidence. So Sergeant Buchnick testifies about numerous pieces of physical and digital evidence. He removed articles of clothing that O'Keefe was wearing from evidence packages and displayed them to the jury. Oh, was this the thing where I remember this? So Buchnick also answered questions about a series of surveillance showing Reed's SUV. He observed the taillight was damaged as the vehicle left O'Keefe's driveway during the storm. Christina Henley, a forensic scientist at the State Police Crime Lab, testified that she had examined a broken cocktail glass. Defense attorney Alan Jackson questioned if a piece of glass submitted as evidence matched pieces of the broken cup, and she said there was no physical match. I think that piece of glass was from a completely unrelated vehicle or something to that, but it was not a match with the cup. Ashley Vollier, who also works for the State Police Crime Lab, testified that she examined pieces of a damaged taillight housing from Reed's SUV that were found in the snow, explaining how the pieces fit together. And then Yannetti gets up there and he questioned how the items were delivered to the lab for testing, basically creating a chain of custody issues. Defense has suggested that the evidence was planted, of course. On day 21, that's when you get the mirrored video on there. And that was a big deal because the mirroring of the video specifically hid important data that would have been on the unaltered or unmirrored video. Defense attorney Jackson, he questioned Buknik about the video. Jackson pointed out writing on another vehicle in the garage and on a garage door. Buknik said the video was mirrored, but he could not explain why. And then he says, so the video is inverted, completely inverted. It's a mirror image, which suggests that the driver's side is the passenger side and vice versa. But the timestamp across the bottom is not inverted, which means somebody had to put that on the inverted, the manipulated, the altered video on purpose, which is a highly damning revelation to the investigators in charge of this case. Jurors also got to hear Reed's voice for the first time. Lally plays the audio of an interview that Buknik said he conducted with Reed. And then he asked, you're aware he was beaten up by Brian and Colin Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized, Reed said. Buknik said he advised Reed at that point to stop talking. But listen to this exchange. I got to show people what we mean by the flipped image. Is it this one? It's this one. Yeah. All right.
The prosecutors showed to the jury may not be what it seems. This video appears to be flipped. The image of it, the defense says flipped on purpose. News Center 5's David Bienick live at the courthouse in Dedham to explain more. David.
Erica, this revelation came at the end of today's testimony here, and it caught everyone off guard. Some jurors even looked at each other quizzically, and some may have wondered if they'd just been tricked. The video shows police pulling Karen Reed's SUV into the Canton Police Department garage after it was seized as evidence. The video appears to show the passenger side, including the passenger side taillight, which prosecutors say was damaged after Reed allegedly backed into John O'Keefe and killed him.
I testify that this is a accurate scene.
But under cross-examination, state police investigator Yuri Buhenik confirmed the video is actually inverted. It shows not the passenger side, but the driver's side of the SUV. At one point, it shows the driver getting out.
Not once did you mention that this video is actually completely inverted.
I did not know.
How did you discover that the image was inverted?
I saw the word police and thought I had dyslexia.
In the video, the
All right.
word police appears backwards on another vehicle parked in the garage. So does the number 4 on one of the garage's overhead doors. Defense attorney Alan Jackson believes it was no accident.
The timestamp across the bottom is not inverted, which means somebody had to put that on the inverted, the manipulated, the altered video on purpose.
Here is the video.
Hey, Dominic, I need your expertise, sir. I need you to jump on.
Yes, sir.
Okay, so you are inverting a video. Would it also invert the timestamp, or would the timestamp just kind of be left alone?
No, it would also like mess with the timestamp as well.
What do you mean?
So like if you invert a video, usually it'll like the timestamp will show. It'll invert the timestamp as well. So it'll be like the hour
backwards.
Yeah, backwards. There you go.
Damn. So literally, how could that be anything but intentional then? If you're flipping the video like that, but fixing the timestamp, I mean, isn't that so? Are in your opinion? Okay, I'm making you an expert, Dominic. In your professional opinion, would it be your position that if you were to find a video inverted where the timestamp was not inverted, would it be your professional opinion that it was intentional?
Yeah, 100%. So like in this case right here.
Is there any way in which it would not be intentional, meaning you could flip the video while leaving the timestamp intact?
No, not that I know of.
F. What do you think of
Yep.
that, Eliana? I think that I think there's something wrong. Hey, thanks, Dominic, for all that. He just muted himself. He's like, all right, he's gonna go back to making his sandwich. Yeah, so that was like that was a really big WTF moment at trial. So we talked about we haven't even gotten to the regrettable text messages yet. But that was on day 22. So Michael Proctor, there was a lot of questions about whether or not he was even going to be called to the stand, because calling him to the stand was going to create a lot of issues for the prosecution because of his behavior in the case. It might have created chain of custody issues. But this is essentially is what happened. So he was made to read a series of disparaging text messages that he sent about Karen Reed. After reading one of the messages in which he called Reed a whack job and an expletive, it was a see you next Tuesday. He apologized to the jury for his unprofessional comments. I guess apology accepted or not, but in one message he sent to coworkers and supervisors while searching Reed's phone, Proctor wrote, "No nudes so far." It's the equivalent of somebody going through your phone and just searching for nudes because you're involved in some kind of a crime and you volunteered your phone as evidence. And they're over there looking for, stuff, fallacious things. Her physical phone. Jackson asked Proctor if Proctor had ever looked for naked pictures of male suspects. Proctor said, "Jokes don't have any bearing on the fact and integrity of this case." So he didn't answer the question. He just was being a dick about it. At times, Proctor's voice was barely audible as he read messages that he described as juvenile and unprofessional at best. He testified, however, that the messages did not influence his investigation. And earlier in the day, Proctor's testimony had focused on Keefe's body and physical evidence from the case. He testified about seeing O'Keefe's body in the emergency room and noticed abrasions on his right arm, swollen eyes, and blood on the back of his head. So there's that. The swollen eyes is what gets me. Because he basically had black eyes, and he had blunt impact force trauma to the back of his head. What he didn't have was cracked ribs. What he didn't have is massive bruising. What he didn't have is other injuries to other portions of the body consistent with what we saw in that 3D rendering, which is the prosecutor's theory of the case. It looked like a guy just got in a fight. He and Massachusetts State Police Sergeant Buchnick then traveled to Reed's parents' home where he saw Reed's vehicle, and that was that. So on day 23, Proctor's still on the stand. He faced more tough questionings about very regrettable text messages about Reed that he sent to friends and other colleagues. Proctor was the lead investigator in the case. Her defense team, Reed's defense team, argued that she had been framed, all that stuff. When asked by the defense, Proctor agreed that his messages dehumanized Reed. The texts are appalling, wildly unprofessional, to put it mildly, and it's hard to imagine they won't hurt the prosecutor's case in the eyes of the jury, said one law professor who spoke to the AP about the case, which is, neither here nor there. Let's hear him talk about.
Back on the witness stand, Trooper Michael Proctor was again forced to read more of the text messages he exchanged with friends, including one who asked if Karen Reed was hot.
Yeah, she's a babe. Weird Fall River accent, though.
Proctor says he wasn't initially sure if it was intentional, but determined on the same day that John O'Keefe was killed that Reed was responsible.
We went through the overwhelming amount of evidence against Miss Reed that she struck Mr. O'Keefe with her vehicle.
Proctor said he did not initially disclose that he knows some of the witnesses in the case, and that during the investigation he went out drinking with one of the witnesses' brother, a Canton police officer named Kevin Albert.
In fact, the two of you got so drunk that Kevin Albert left his badge in your cruiser and couldn't find his gun the next morning, right?
The defense showed a text message from Proctor's sister in which she said one of the Alberts wanted to give him a thank you gift. He replied to give it to his wife instead. And in another text message to his sister, Proctor wrote that hopefully Karen Reed would kill herself.
There was a figure of speech My emotions got the best of me based on, the fact that Miss Reed hit Mr. O'Keefe with her vehicle and left him to die on the side of the road.
Yeah, so that's kind of, I don't know if it's the equivalent of like Mark Furman-esque testimony from the OJ case, but that's pretty effing bad. Julio says, thanks, Julie, for the $4.99. She says, Higgins' Jeep had a plow attachment too. Maybe in his drunken state, he hit O'Keefe when he left. Maybe.
Yeah.
There's another plausible theory. So many things could have happened as reasonable doubt. My rule, reasonable doubt, whenever I have ever tried a jury trial in a criminal case, I always make it a point to instruct the jury in a voir dire when the DA will let me get away with it. And in my opening statements, they're like, look, you have a burden. The people have a burden. Their burden is they have to prove their case to beyond a reasonable doubt. That doesn't mean they got to put on a perfect case. But what I submit to you is this. At the end of this trial, there's going to be more than one plausible explanation of what happened in this case. And most of those explanations are not going to involve the guilt of my client. And if you agree with me by the end of this trial that that is the case, and there are multiple plausible scenarios that don't involve the guilt of my client, then by law, as mandated by the Constitution of the United States of America, my client is not guilty. All right.
You got it out of their system.
Every now and then. All right. So let me continue with our recap. So Proctor, he goes on about that. On day 25, they finally get a crash expert in there. And he says that the injuries were consistent with an SUV strike. So this is what he said. Trooper Joe Paul, a crash deconstructionist. Now, I've heard some people on TV say that this evidence is beyond 100% proof that Reed's vehicle struck O'Keefe. I disagree, and I'll tell you why. So a crash deconstructionist testified during the afternoon about how he tested Reed's SUV for speed and braking in the parking lot outside the Canton Police Department. He also tested what she would have seen behind the vehicle while in reverse. Paul testified that the SUV's data collection system showed it was put into reverse. The driver pushed the accelerator 3/4 down and sped up to 24.2 miles per hour, hitting a person at that speed, Paul said would cause the kind of injuries he saw on John O'Keefe. He said that. The lacerations to the arm from the taillight, the dent with the scratches where his hand could be, those are something that would be consistent in this particular case with striking the Lexus, Paul said. But what that's not consistent of is the medical injuries that O'Keefe sustained. So consistent with striking the Lexus, fine. And there was video of that. And I think that there was a video of her backing out of her driveway and cracking her taillight even more. But the SUV's data collection, they could tell a lot of information about it. Fine. It was put in reverse. She put the thing 3/4 down, but what that tells me, she didn't floor it. Is that significant? I don't know. But she got up to 24.2. He says that hitting a person at that speed, Paul says, would cause the kinds of injuries he saw in John O'Keefe. But he's not a medical doctor is the point. How the F would he know? A crash deconstructionist. And then there was other evidence they got up after him that disagreed with that. And so there was that. That was day 25. On day 26, they brought in digital forensic evidence. The jurors heard from digital forensics experts, Ian Whiffen, who testified about when Jen McCabe's search for Haas Long to Die in Cold was conducted. He explained the search was conducted in a tab created at 2:27 a.m., but that the search itself was conducted at 6:24 a.m., which conflicts with the defense's assertion that she conducted the search before O'Keefe's body was found. Trooper Nicholas Guarino testified about his analysis of the phones, and Guarino said that the defense's cell phone expert reached several incorrect conclusions, including the phone calls were deleted, and through his testimony, Prosecutors also introduced more evidence that Reed and O'Keefe has been fighting. But Ileana, are you basing Karen Reed's guilt on this one text message from McCabe?
No.
No. And so it's not really all that important. For example, if she texted that at 6:24, does it change your opinion about reasonable doubt in the case?
No.
Okay. My only point. December or on day 27, they talk about the profanity-laced voicemails. Nicholas Guarino, he goes back to the stand. He's questioned about his analysis of O'Keefe and Reed's phone logs. Guarino said that Reed made 53 phone calls to O'Keefe in the hours after 12:35. And on January 29th, 2022, he said she left 8 messages on O'Keefe's voicemail, which were played for the jury. And they were angry messages. They were voice messages of a woman scorned. Oh, she was so pissed. Just to quote, John, I am here with your effing kids. Nobody knows where the F you are. You effing pervert. And she goes on. One of the messages that was received at 12:59 a.m. Then at 1:11, it's 1 a.m. I'm with your effing niece and nephew. You effing pervert. You are an effing pervert. I'd play them, but I don't have the audio directly. Then at 1:18, 7 minutes later, John, I'm going home. I cannot believe inaudible. I need to go home. You are effing using me right now. You are effing another girl. Name redacted is sleeping next to me. You are an effing loser. F yourself at 1:18. So she's texting him like he's still alive. I don't know.
Yeah.
To me, that is more evidence. Again, this is the prosecution's witness. This is more to me evidence that she did not think that she ran him over when claimed. So on day 28, prosecution finally rests, and then the defense gets to call their witnesses. Their case in chief was much shorter. They call chief medical examiner Dr. Marie Russell. He was a retired emergency room doctor and medical doctor for a prison in California, reviewed hospital records and pictures of O'Keefe's injuries. He sounds like somebody out of Lord of the Rings. He's got like a really cool accent. He's got a bitchin' accent. He says, I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of injuries. And then they continue on. On day 29, the defense finally rested. They called 3 final witnesses in an effort to cast doubt on the prosecution's version of events. Dr. Frank Sheridan, a retired, I apologize. Sheridan was the one with the Lord of the Rings voice. He is a retired forensic pathologist who worked previously as chief medical examiner for San Bernardino County in California. I've seen his name floating around a couple times in the past, not anytime recently, but he testified that he would have expected more bruising if O'Keefe had been hit by a heavy vehicle. He also suggested that scratch marks on O'Keefe's arm could have come from a dog and that other injuries were consistent with an altercation, not with a car accident. There were 2 witnesses from an independent consulting firm that conducts forensic engineering, who I thought these 2 witnesses were brilliant, but they said essentially that the damage to the broken tail light was not consistent with injuries suffered by O'Keefe on his head and arm. One of the witnesses also suggested that his injuries should have been way more severe if Reed backed into him at more than 20 miles an hour, as the prosecution contends and questioned how O'Keefe's body ended up where it did. And so that was that. And then we got into closing arguments. I'm not going to fully replay the entire closing argument of Lally because it's boring and because we've already been going for a couple of hours now. But I don't know. What do you think of all of that? That's a synopsis of all of the evidence that the jury is currently deliberating.
I understand why the jury cannot reach a decision.
All right, make an argument that she's guilty.
Me? Oh no. It's just the evidence is just not there.
Okay, if this was a civil case, let's say it was a wrongful death civil lawsuit, And the standard of proof is preponderance of the evidence. Make the case then.
Then in that instance,
could you say that it was more probable than not that Karen Reed caused the death of Mr. O'Keefe by way of her negligent actions on the night in question?
I don't know. I don't think so.
I submit to you, if the answer is I don't think so or I don't know, then the answer is no. You cannot.
It's not. It's just I'm not convinced. Like, I don't see the connection. It could have been anybody.
Talk on the Net says, keep in mind that the Lexus SUV comes with cameras and locking brake system. They destroyed the car's black box with all the information. I don't think that they have black boxes though, do they?
Maybe it's called something else, not a black
Yeah, I don't
box.
think it's called a black box, but they definitely have like computer systems that you could download all that information from. Yeah, I'm not sure if you're even prevailing on a civil case in this matter. So I don't know. We have a jury that looks, by the way, do you know who David Morse is?
Who?
David Morse, the actor.
Sounds familiar, the name. Maybe I don't know by the name if I see his face.
Tell me who this looks like. It's been bothering me this entire case. Let me just pull him up. Tell me who this looks like. He was an actor in House MD. He was in The Green Mile. He was in that one movie, The Negotiator, with Samuel L. Jackson. David Morse, this effing guy. He plays cops in all of the movies. Tell me he doesn't look like Mr. O'Keefe.
A little bit, yeah.
Oh,
Maybe
you're no.
like an older version.
They're like brothers. They're like twins. They're literally like twins.
Oh God.
Oh, all right. So that is our synopsis of the Reed trial so far. Here's what I think. We got to hung. The jury is threatening to hang. I don't think that this is going to end today. It makes way too much sense to break for the weekend, come back fresh on Monday, and start again. I'm curious about what the numbers might be in terms of guilt versus innocence. If there's any holdouts on the side of the prosecution, I'm really curious about what evidence they're holding on to that they're claiming is beyond reasonable doubt that they're going to say that Karen Reed is guilty of anything. In terms of leading up to the death, I don't know. But that's where we're at. So yeah, I don't predict a hung jury. I predict that this is going to go to verdict. I just don't think that we're going to get a verdict until Tuesday, possibly. I'm going to call it. On Tuesday, we're going to have a verdict. If we don't have a verdict on Tuesday, now you would probably start thinking